Akash.
Hi.
Good morning and good evening. I'm told that people are from all
Yes.
over. Yeah,
Okay.
wonderful.
So yeah, let's give another minute. Most people are joining.
Uh, I'm starting. Yeah, yeah, yeah. Yes, yes. Thank you. Bye. Yep.
So Vivek, I'll just do a quick introduction of you in another minute, and then we'll get started.
Sure. Sure. Thank you.
Okay, why don't we get started? It's already 2 minutes over. So I want to introduce today Vivek Sadlai. He's a co-founder of Legalogic. He was formerly with Persistent Systems for also many years as a head of legal and investor relations. So today he's going to talk about compliance requirements, due diligence, legal requirements. He's of course expert in this area. So we are looking forward to his talk. With that, I think Vivek, we can see your slides. So please go ahead.
Okay. Thank you, Sanjay, and good morning and good evening to everyone. I've been speaking with Anand, Vijay, and Madhav for a while, and I, I have a, I have a, I have a relative understanding as to what all of this is, but bear with me if I'm, going fast, slow, intervene. This is unfortunately not as effective when we are in the same room, but let's try and see how best we can utilize our morning time next about 60 minutes or so. Please do drop in your question in the chat box, and let's see how best we can utilize this. And again, the whole idea of me talking about this is to provoke some questions, provoke some thoughts. This is not a lecture. This is more of an interactive one to for all of us who are on this call to understand, because there is no yes or no. It's very situational at times. It is extremely dynamic in terms of what you pick and choose. Having said that, there are certain principles that cast in stone in my 25 years of experience in terms of how some of these things pan out in the short term, in the medium term, and long term. And that's what we're going to talk about. And I mean, the cliche example that comes is of Paytm, and we are seeing what value destruction happens when you take certain things in a different way than how a regulator looks at it. And what we have seen is that some of these things get caught in the web of the regulatory environment that you and me are in. And many of you actually are building tools and whatnot to make this happen. So it is coming to full circle where everyone's going what we call as e-governance, and that's one of the reasons that it is becoming easier to be compliant. And if you're not, then obviously there is a fair bit of backlash that happens, and we've seen this in last 1 month as to what is the value destruction. We've also seen someone like Byju's. We've seen someone like there are multiple examples in the old economy called Enron, and all of them, if you look at the issues, have been governance issues, have been non-compliance issues, have been playing with the regulators. And that's exactly what my talk is. My talk is in terms of how can you be well governed and what does it take to do that. And there are certain principles that I'm going to share based on my experience. And these were the bad examples, and I have a great example in Persistent, where I've worked for so long. Anand Deshpande, who created this company, and I've seen this from very, very close quarters in terms of how good governance can drive value and can drive value for a long period of time. And Anand had this conviction of getting things done right in the right manner first time and every time. And we saw that when it came to our VC investment, when it came to the IPO, when it now the market's rewarding the great performance on top of the governance. So I think it's a sum total of how someone looks at it. And of course, these are large companies that we're talking about. But believe you me, when I joined Persistent, it was a 100 people company and $3 to $4 million in revenue, and which is today what we see a super large global company. So these things happen in a lifetime, and we've seen this firsthand. And we continue to see the good side of it and the bad side of it. And these are the examples to essentially look at. Obviously, my presentation is no substitute for the legal advice, because your situation could be a little different than what my presentation is. So take it with a bit of a pinch of salt in terms of what this presentation is about. It's not legal advice or substitute for legal advice, but will help you to look at the principles attached to it. I think one of the key things that I have seen, that a good company which goes for long shot and long term versus someone who struggles and spends time and money, and it's all about time on hand, right? How quickly you are able to monetize your idea, how quickly you're off the ground. Are you buried in the questioning overall from your own partners, from your own ecosystem or regulator? That is everything all about. So what do you do when you start any venture, and when you are sort of looking at anything incremental, which is say for example you're taking an investor, you already started, you're taking an investor, you already are off the ground, but you are looking at setting up office outside of your home territory. You're looking at venturing into something new within the same entity, or you're starting completely afresh, a new idea, a new company. It's important that you select your partners well, your lawyers, your accountants, your CFOs, your business team, and what have you. I think that's the very critical aspect of it. And each one brings in their own expertise. And obviously, you might be doing your second venture, third venture, and what have you. But what is important is to pick brains of those who do this for their living. And when you look at what are they doing for their living, clearly they bring in a differentiated approach. They become your sounding board. And as things could at times get into a mess, they can help you settle that real quick. It's important to get in Europe, there is a 4-eye principle, which means that they say that 4 eyes are better than 2 eyes. And I'm actually a great fan of this particular statement, that 4 eyes are better than 2 eyes. And if it is 6 eye, nothing like it. Obviously, you don't want to create bureaucracy. For a small problem, you don't want the whole world to solve it for you. But then those who actually do it for their living and can help you do that is very critical. And while you select your partners, be very clear as to who provides you bandwidth. Obviously, the advice is important, but remember that the bandwidth is also important. As they say that the doctor is important, but doctor with time to you and specific time to you is as critical as what you see a doctor in itself. So you got to pick that particular thing. If someone is super busy, is not able to provide you any time, then I'll take it with pinch of salt as to he might be a great professional, but at this point in time you need someone who is available, who will pick up your call, who will answer your email, and is not going to delay it beyond a particular thing. The second thing is that you ought to have a business plan. And remember that business plan is not just about the numbers. This is both the qualitative aspect of your business and the quantitative aspect of your business, both taking together. This is not just the P&L statement, the cash flow, and the resultant balance sheet. That those are financial statements, those are projections. The business plan is about your team, is about your market, is about your go-to strategy, and it could be one page each. It need not be a McKinsey type report, deep dive, super complicated, uh, but it has to all culminate into one single document that you are able to reflect on and are able to measure in terms of what's going right and what is not going right. As they say, what gets measured goes forward. And if you don't have anything to measure, then obviously while you're trying to make all of these things work, but then what is it that you are what you started with versus where you are is always a question. Are you in tune? Is the money being spent in the correct manner? And so on and so forth. So I think this business plan prep before you actually take a plunge is another critical and key aspect of how you start your own venture or anything new, as I mentioned to you, within the venture that you already started. Both uh, should require a business plan, and that's how good businesses go distance. The other thing is that if you are in a niche area, which you say, many times people and clients come to us and say, hey, you know what, this is something which is a very unique idea and no one seems to be doing it. Now that sounds very romantic and that sounds great, and it could be the case. But if that is the case, please have that validated from your legal counsel. Remember, in this world, almost everything is discovered now. So what is so unique in your idea that no one else has thought about? And if that's so, and it could be the case, you should make sure that it is tested before it goes through. So there's a business in India called Book My Show, and I'm sure everyone has used it, and possibly we use it frequently. It's a default now in terms of online booking of tickets in the entertainment industry. And when they started in India, the laws didn't permit what we call as over the counter. Let me step back. What India did not allow was anything other than over the counter sale of tickets. And what is Book My Show? Book My Show is an online ticketing platform. And they face this particular issue. And that's one of the reasons why you see many times in the whole scheme of things, you have a printed tickets available in the window where you are going for a movie or you're going for some of those events. And it was an accidental check from them to find out as to why those ticketing business online could be considered as gambling versus a real business. Of course, a lot of water has flown, but the point here is that, say, for example, people come with a fintech idea. Now, the fintech ideas could be P2P and whatnot. It needs to be tested because, whether it is aligned with the RBI, we use the prime regulator, or someone comes with the capital market ideas, is that primed with SEBI and whatnot, is very critical before you start to pump in too much of money. And the fix could be very uh, easy. But remember, as you're building your tech and starting to spend money and deep money into it, you are effectively looking at a situation where, that tweak could come before you start to do that. So my limited point here is that sometimes when you think that your idea is super unique and no one else has attempted that, then I think you should definitely do it. Even though you feel that your idea is a bit unique, and very few people are there, I would still check that from a legal validity. There's another example of the real estate today is very, very hot and very expensive. So people say that I want to participate in it, but I want to take a small chunk, what we call as like a mutual fund unit. Now that business is shaping up as we speak. Now, what is the legality of it? And there are nuances around it. I would, if someone comes to me, I tell them that, let's check what you guys are trying to do. I ask them to send me their business plan or, whatever is their presentation, and then start to check whether that's like kosher from a regulatory standpoint. If not, we pick up and say, hey, you know what? These are the checks and balances that you need to take. So that's just a quick thing before you start. It makes a lot of difference in the overall scheme of things. Um, let me see if there's any question. All right. Okay. There's none. So what are the legal structures in India which are available or outside of India? I kept this sort of, tuned to India situation, but in the US, you have C Corp, S Corp, and LLC. Like in India, you have a private limited or LLP. We don't like partnerships. We don't like proprietary firms. We just think that a limited liability is an important concept. We think the easiest pick for you to do a private limited or an LLP. LLP is nothing else but a limited liability partnership, which is akin to partnership, but because it's an incorporated entity, the liability is limited. And why do we not like partnerships and proprietary firms? Because the liability, any liability is to your person. As against that, the liability is limited to the extent of capital that you infuse in a private limited or an LLP. Very, very important distinction. Now, how to choose between a private limited or LLP? There are various things, and people talk endless about, I'm going to save tax and what have you. But remember, if you're really starting afresh, at that point in time, a profit is tax is a principle to understand. When do you make profit is another thing to look at. What you are looking at is if your business is going to require capital, which is a third party capital, and I'm talking about equity share capital, there is no other way but a private limited company to be set up. And we can debate to death in terms of other areas. But remember that LLP, one, is very new as a structure. Two, is a bit administratively inconvenient. Three, from a regulatory standpoint, should there be any dispute or non-alignment between the partners, then LLP becomes very tough to operate, and therefore investors by far would expect a private limited company to be set up and not an LLP. So think, what is your business, and is your business going to require capital every now and then? And at that point in time, I would pick up private limited company over LLP and not get into a situation where at that point in time, if the investor comes, if the opportunity comes, then I'll create a private limited company. LLP has limited compliances. Believe you me, there's very few differences from compliance standpoint between LLP and private limited company. But depending on your business, set it right. You don't want to create a situation where you then end up converting LLP into private limited. It's a not easy process. You will end up spending time and money, and that's not what you would want when there is a potential event coming in. And there are ways and means of converting that and bunch of it. But why to do it when you know that your business is going to require capital from a third party? I would go and create a private limited company. For someone like me who runs, say, 90 plus people law firm, my capital requirement is, nothing else but the cash flows. And therefore, for a business like mine, LLP works. Or if you go to the US, you will find that professionals operate as LLC, or if you operating your own consulting firm, or your own husband and wife show and what have you, you will get into an LLC situation. Otherwise, you get into a C corp, which is equal to a private limited company. So various ways of looking at it, but two things important. One is you don't want to create a partnership or proprietary firm. It exposes your person. You're looking at clearly limited liability. And the second is that if you are seeking an external capital as you go forward, you're looking at private limited and not an LLP. If your business doesn't need third party capital and you think that you could operate in a nimble manner and there is no exposure to a third party, LLP works great. The other question that comes to us every now and then is, should I create an entity in India or outside of India? Now, for that, I don't have a principle-based answer like I did for a private limited or LLP, partnership, proprietary. In India or outside India depends on several factors. But here are top three from my perspective. People come and say, hey, can I create something in Singapore, Dubai, US, and multiple jurisdictions because it has tax advantages and what have you. My question to them is that where do you end up using that money? If the money is going to be utilized in India, whatever you earn outside of India as you bring into India, there will be an expectation that it's a tax paid money. There are no free lunches. And therefore, first question to ask is that where would you end up consuming this money at the time when you have an exit of your company? And you have to think it now so that you get the structure right to the extent possible. Obviously, things change and you can change it, but all things remaining same, what's your best guess in terms of where would you see an exit and where would you want that money to be utilized and consumed? And if the answer is that it's going to be in India, then take a deep breath and think, if it were to be in Singapore as a holdco and you get an exit in Singapore and you get money back in India, would you have the same situation on tax or not? The second important thing is that where are your customers? Where are your investors? Where is your ecosystem? Who's asking you, from an external standpoint, that you need to look at external territory than India? And you have multiple examples where Indian companies have, gone distance. You have multiple examples where outside of India companies have gone distance. So both have merit, but it needs to be looked upon from what works for you. And it can't be because someone who's my friend did that, and therefore I need to do it, because clearly your business and your priorities, personal priorities, your intellectual property, your way of doing business, the way you get regulated, all comes to play. And therefore, it's no easy answer in India or outside of India. But to the extent you are able to answer those questions, and those questions, many of those will come from the business plan in the last slide and the slide that I'm projecting now. You see this as a business plan could provide you with some clarity in terms of where should you set up in India or outside of India. And when you build the business plan, there could be sector-specific compliances and considerations, like a lot of companies now doing defense work, and that's becoming gold standard as India opens defense sector. And there are various models coming in, and there are foreign exchange regulations in terms of who can do what. There is a Make in India situation where small and medium enterprises, MSMEs, are being given preference over anyone else. So do you fall into it? Are there any benefits? Going to a particular state, does that entail any kind of benefit? Those are good questions to ask if you are in that kind of business and you're trying to look at that kind of business. And that could provide you with a great impetus in terms of, what works. which again, India, if you see, like the US, on a company formation is a federal in that way. So in the US, you say I'm a Delaware C corp. In India, you don't say that. You say that you are incorporated in state of Maharashtra, because you are essentially, your registered office is in state of Maharashtra. Though when you go to state of, say, Karnataka, or state of Gujarat, or state of Tamil Nadu, you don't need to create a new company. All that you need to do is to do what is the state specific law in India. Many of that is called as Shops and Establishment Act of that particular state or a city, and therefore you would end up taking the registration and then starting. But the company is one company at that point in time. But where do you operate from? Where do you operate from would determine the benefits that you get, and therefore, understanding those, if there are any, and what are those concessions, for how long are they valid, and things like that would become interesting as you look at this. Let me see now the question starting to flow. I see Rahul asking your inputs regarding incorporation as Delaware C Corp versus incorporating in US states, say CA will be useful. Yes, Rahul. So the default is Delaware C Corp, because for, say, for example, those who are outside of India, and rather who are in India or outside of the US, setting up shop in the US to start with, Delaware provides a better platform from regulatory angle. There are other areas where Delaware counts better as compared to, and it all has to do with the cost effectiveness of implementation. Should there arise any disputes within the partners, etc., then the Delaware C Corp is a better outcome than, there is state of Nevada, the state of California, and bunch of those that you could incorporate, but Delaware is by far. What I'll do is, I have a note created about it. I'll share it with Madhavji and others, and hopefully, it will reach you as well. But there are distinct advantages that the Delaware C Corp has over others, and that is to do with the way the outside of India, rather outside of the US companies are governed should there be any issues that arise, and they do it with a bit of a kid's gloves as compared to other states as such, and that also relates to the cost associated with it. Madhavji is asking a question at the beginning. Many a times entrepreneurs set up some form to start with, and then they try to convert to get more information. Yeah, how do you manage such situations? And what I was trying to say is that your business plan should provide your legal counsel an idea in terms of what you're trying to do, and then you will essentially have ideas in terms of which state provides the best outcome for your business idea. If it is sort of a software or a technology idea, then obviously it's a cookie cutter answer in that way. But you looking at a situation where you don't want to be you don't want to let go of the government schemes. So the way I would look at is the business plan shared with your legal counsel, and legal counsel helping you get to what the government schemes are. Now, you looking at a situation where you provide those inputs and you get those in as an understanding early on. Therefore, you avoid all the conversions and all the capital gain taxes and the indirect taxes and the stamp duty that come along with it. From that standpoint, you're looking at a situation where you would want to share this before to get the setup right. Okay, let me go to the next one. Uh, and as you take the plunge, these are some of the important situations from my perspective. Uh, what we like is that the trademark, the domain name, and the company name all should be done simultaneously and before you actually set up. In any case, as you set up a company, you can't do it unless you find a name for yourself. And as you do that, you get into a domain name and you also get into a trade name. For example, today Legal Logic is legallogic.com. We started with .co.in. We just didn't get .com. And obviously, in the hindsight, now that we have .com, it took a while and it took some money to get that .com. But essentially, we were hung up with this name Legal Logic, and therefore we went ahead with this particular thing. But if you have choice and if you actually look at what is available, then you would want to get the best of all three: the trademark file, the application I'm saying with the registry, and if you are doing businesses in India, outside of India, and bunch of it, then you actually cover it in that manner. It's a slow and low cost, but it's an important thing. And then you get your domain names, and you also get your company name aligned if your company name and the product that you're selling and the mark that you are going to look at is all the same. But that's a very, very critical thing. A low hanging, but a very, very important thing. You don't want to get it wrong as you start. Your constitutional document in India, we call that as an Articles of Association and Memorandum of Association. In the US bylaws, they don't go with the templatized one, ask questions. Many of them can be customized. Many of them are your own thoughts. Remember, it's your company. You ought to do it the way you want it, and therefore ask questions to your counsel in terms of what is variable. Some things are cast in stone, that's just law. You can't do much about it. But most of it can be tweaked to what your requirements are. And to that extent, you could ask the questions, relevant questions, and get those things right. One of the important things that we've been a great proponent of is the founders agreement. Now, in the US, what we have seen is that this comes as a sort of a package in terms of this becoming a gold standard, and without which not the businesses don't start. But in an Indian situation, many a times, we have seen and heard that, hey, you know what, he's my friend and he's my whatever. And we're starting business, so we know each other for 20 years. We have family relations and what have you, and that all is fine. But then on the business side, this founders agreement encompassing, it's like a shareholder agreement, but it's just that two founders as shareholders are coming together, joining hands and taking the plunge, and therefore documenting their relationship inter se is a very critical thing. A shape and form, you decide, but it's important to document what will happen. Just as an example, if someone slows down and someone wants to sell and someone wants to sort of get into the middle of the road and raises his hand saying that, hey, you know what, I'm not going to run now anymore, how does things happen? You need more capital, and that capital is not forthcoming. How do you look at, one is willing to invest, one is not willing to invest, one is wanting to get an investor, the other is not wanting to get an investor, so and so forth. There are multiple things that come to your mind as the relationship matures over time and the business is doing great. Some of these questions come, and how do you plug them before, in terms of your shareholder agreement, in terms of your founder agreement, is very, very, very critical. And then as a corollary to that, things is that many times the trademark possibly, or the domain name could be in the personal name of the founder. Don't do that. As soon as the company is, and there is a reason why you do it to start with, but as soon as the company is incorporated, make sure that everything belongs to the company. Many times, to save filing fees, we have seen that the patent, which is the base and the backbone of the overall company, is in the name of individual founder. And those are very risky situations. Things change. You don't want to be you don't want to put the company to chance with certain of these important and critical things remaining in the founder's personal name. They need to get assigned as soon as the company is incorporated. You could compensate the founder who took efforts to do all this. It could be in the form of cash, shares, and what have you, but make sure that everything belongs to the company. That's just the pure hygiene. If you are in India, do register under the Startup India program. There are two types of registration. One is with DIPP, which is most of the companies get it, unless you are a reconstructed company or are a subsidiary of any overseas companies. Then obviously those benefits are not available. But if you're a pure play domestic company in India, then you have the chance of getting registered in the Startup India program. And once that you're done, the second step is to get what we call as the tax benefit associated with the Startup India program. Those are too far and few. You need to demonstrate a very differentiated offering. You need to be innovative. You need to be looking at either creating a large employment or cutting super cost associated with doing business, but it has to be a very unique thing that could give you the tax benefit. So not many companies get the tax benefit, but most of the companies get registration on the Startup India, and there are fiscal and non-fiscal benefits associated with why you why you would want to register in the Startup India program. And then obviously there are other registrations, your business specific in which industry you are in. If you're in the food industry, the FDA, or you are in the pharma industry, and so on and so forth, or specialty chemicals and whatnot. But then those other registrations will also become critical for you to understand as to what makes you continue to start your business as such. Once your company is set up, you have certain minimum legal documentation that you ought to keep. Like the employment, you would go and hire at some point in time. You want to create right set of employment documentation. You want to create an IP protection. We call that as an invention assignment and confidentiality agreement, that all employees and consultants who are working for you would effectively assign all the rights in the work that they do for the company, given that it's work for hire, for which you are compensating them either by shares or by cash. But it's important that everything, as we spoke, from an employee and from a consultant or what have you standpoint, belongs to the company. That IP protection is critical. And then it ties up with your employment document on the employment agreement with your employees, and what we call as an employee handbook. Of course, the employee handbook and the detailing part of it will depend on the scale of your operations, but the early you do it and as you start to hire more employees, it becomes important that you have all of these things in a structured manner, and that could give you an edge at a later point in time. Your customer documentation, depending on which kind of business you are in, a bare minimum of those templates customized to your requirement is important. And obviously there are templates which are floating around on the net from your friends. But again, making that small investment is important to make sure that they are all to your, we have seen people using template and your jurisdiction clause is some godforsaken state in the US, or arbitration. People don't look at all of these things, and it changes the hard work that you are trying to do. And it's a critical client of yours, and using your template, and then just small little things can take you into a different trajectory altogether. So while templates are good starting point, but can't be used blindly, and they need to be customized to your business requirement, that investment again goes a long distance as such. The other important, very, very critical thing, and which is extremely difficult to get back in any jurisdiction, is managing share cap table. And what do you mean by that? It means that eh, how many shareholders would you want to have as you start? How much would you want to dilute? What is your ESOP program? Are you looking at funding at a later point in time? And one of the sort of good principles to see is that the founders continue to hold at least 60% equity after Series A. I mean, this is not something which what I call as a must-have, but from your perspective, it's important that as you leave Series A, you holding around 60% stock in the company, and that's important to manage because the rights associated with what you dilute could take you down in a different path. And obviously, US is a matured market where people understand what rights go to what level of investment. But as India matures to a next level, managing share cap is a very critical factor. What we many times see that there is an early dilution leading to multiple set of rights, leading to a situation where the founders vision is blurred by the way in which the investors want it to run. So aligning that becomes very critical. Having too many tail shareholders create an issue in terms of as you are going forward and seeking more investments. Just the administrative hassle of getting all the signatures, getting everyone to align becomes a challenge. So some of those are gold standard in terms of when you create your share cap table, when you start to dilute, when you start to create ESOP program, when you have convertible note, when does that convert, how much, what does your fully diluted shareholding pattern look like, and when you are going for a value round with your investors, with your institutional investors, then what does that mean and how does that correlate? All of that becomes an important factor to look at as you start and as you start to get into a third party investments in your company. Let me see. I have one chat. Yeah. So Mahadev is asking, can somebody set up company with Maharashtra Shops Act and still do business outside Ishnaal Services business? Is there any limitation for initial 3-4 years? So yes, you can. As you incorporate the company in state of Maharashtra, you can do business outside in other states in India. You ought to go and take registration in the state in which you want to do business. In that state shops and establishment, if you are services business, if you are manufacturing, you ought to have a factory set up, and then there are different parameters to a manufacturing entity. But for an international business, you are looking at a different situation altogether. You're looking at registration in that country separately and not with Maharashtra Shops and Establishment Act registration. Remember that each jurisdiction, as you go, you ought to take a visa, and that's exactly how the businesses work. For individual, it's visa. For companies, it is going to be a registration as required in that international territory, and it differs from country to country, city to city. Rahul has a question: is it a good practice to allocate ESOP before external funding round? So Rahul, what happens is before any external funding round happens, the investor is effectively asking you to set up an ESOP because he doesn't want to dilute in favor of ESOP. Think about it. You own 100%. An investor comes in with and you dilute, say, 15%, and then create ESOP of 10%, then the investor drops from 15 to 13.5 because there's a 10% dilution for ESOP. And the investor says, hey, you know what? I'm coming into the company with ESOP assumed as a line item, and I'm not going to take the dilution for the ESOP. So create ESOP before I come in. Now, the question is, how much before the investor comes in should you create ESOP? And that answer depends on what trajectory of business that you are in, and what is it that you are looking at what growth stage are you in, and that should determine your answer as to how much before the investment comes in should you create ESOP. But should it be before the funding round? Most of the times before the funding round, external funding round, the ESOP is created at least as a line item, so that the investor is not diluting for ESOP. He expects that as a pre-money cap table line item. And again, some tidbits from my perspective is that being always ready for investments for M&A or for any other inorganic opportunity is not too difficult in terms of being well governed, keeping all your documents in shape, you managing your contracts well in terms of the repository, and you're always prepared for a diligence on you. And it is always good to have money in the bank quicker. And one of the ways to get the money into banks quicker is to be ready with what a potential investor, what a potential strategic investor, what a potential acquirer, or any other partnership opportunities, strategic partnership opportunities that come your way. So that's an important one in terms of being ready. And if you do things right, you always will be ready in that way. Though as your business scales up, as you focus more on your customers, unless what we discussed is taken care ahead of time, it becomes that much difficult to sort of manage as the chaos starts to run riot in your companies as you start to grow. And therefore, this needs to be done prior to that chaos starting. And you want that chaos, you want all the growth, and you want everything, but it could be easy to be ready for some of these events. Let's see. Yeah, I mean, this is what I had as a quick presentation. Happy to take more questions, Sanjay and Keith.
Thank you, Vivek. This was very comprehensive. So let me see if there are any questions coming from participants.
I can see Mayur asking questions. What are the key non-negotiable legal docs to have tech company in India versus US? I think, so Mayur, in terms of non-negotiable documents, wherever you exist, they would remain the same. That's the employment documents, founder documents, constitutional documents, your customer documents, and so on and so forth. The registrations like the GST, etc., they are different from territory to territory. So now in India, what is a must-have? The must-have is the shops and establishments. The must-have is not GST, because the GST kicks in only after you have INR 20 lakhs and more, or 40 lakhs and more, depending on what area of work that you are in. That GST is applicable. But if you believe that you would soon cross that threshold, I would suggest that go and do a GST registration as soon as possible. Labor licenses start to apply when you are 10 people or 20 people, depending on what law we are saying. So again, labor law, licenses, etc., the PF, the ESIC, and whatnot, they all start to hit you once you cross a certain threshold of your employee base, and therefore that may also not be critical as you start. But as you start to hit that threshold, you ought to take it. One of the other important thing is the import-export license. Many of the businesses today either import or export, and therefore we suggest that you get into not just the shops and establishment, but get into the import export license. So then you're not waiting for obvious things to happen. And then a startup registration, if you're not a subsidiary of your overseas entity and you are stationed in India, then you obviously would want to do a startup registration as such. Second question from Mayur is, as we have started new venture, what are the key things to consider while closing? Earlier one from legal perspective, any communication or any legal process. I mean, those can coexist actually, unless there is an overlap and then there is an investor coming into the new entity and saying, you know what, the old entity needs to die. And you have two options there, Mayur, if you want to sort of put it under the bus. One is that you have a fast track process under ROC. The only challenge there is to give an affidavit to say that, hey, you know what, if anything comes up from any regulatory bodies, then you will step in as a director to make it good. The other one is to go to National Company Law Tribunal, and then there is a winding down process, and you could actually spend a little more time and money, but it's a peaceful thing. It dies completely without any tail remaining. So two things. One is both businesses can coexist. The reason why you would want to close clearly is because your investor is driving you to do that, or you don't want to create unnecessary overhead because you don't want to use the old entity in the new business, and that's a conflict, and there could be partner issues and bunch of it. You would want to do that. There are two options. One is the fast track ROC scheme, or a full-fledged one, which is if the old business is running for a while, we suggest that do what we call as NCLT, National Company Law Tribunal winding down process. Akash
Hey,
Patil
Vivek,
is
thank you very much. Just two quick follow-up questions. From the first question, if the business is in India but the customer is in US, any other additional kind of a document legal thing needed for the currency change or any of those sort? The follow-up question to the part two is, under Startup India, are there any easier processes to do, like the registration, the way we have the DPIIT and all? So anything of that?
Yeah, so let me answer the startup. Startup is very easy. You could just go online and do it yourself. If you need help, there are a bunch of people who would be happy to help. There is no further requirement to report after you're done with the Startup India registration. There are a host of fiscal, non-fiscal benefits available to those who are registered in the Startup India program. And the non-fiscal count more than fiscal. Non-fiscal allow you a less intense compliance regime as compared to a non-startup registered entity. And therefore, I'm sort of a great fan of all companies who are not subsidiaries of the overseas entities to come and set up into Startup India and get registered into Startup India. Your first question, if you're exporting to the US, are there any additional compliances? There's only one that I said is the import export license. And remember that you ought to collect money in 365 days. That's what foreign exchange regulation tell you, that you ought to collect the invoice in 365 days. And if for some reason it's getting extended, you ought to do the process through your authorized bank. And from a practical standpoint, I would only suggest that, work with a bank that's nimble and that allows you to collect money swiftly from your overseas clients. There are two things. One is the process part of it that they take, and then the exchange rate that they provide you as the money gets converted from dollars to rupee. That is from a practical standpoint that you need to pick and choose right set of banker and create that relationship so that it's that much faster and quicker without any leakages for you as you start to export.
Thank
Does that
you.
answer your question, Rahul? Sorry, Mayur.
Yeah, thank you, Vivek. Yeah, it's helpful.
Akash Patil
One question. Sorry, go ahead.
Yeah, let me just take this and then come back. Akash is asking, what are the minimum to maximum cost of such advice to Indian startups? So Akash, it all depends on, case to case. Though these are not expensive propositions, my suggestion is that, you should keep at least uh, a lakh or two for getting started. That is a good way of starting. Don't try to be in a situation where you end up in a situation where you have suboptimal advice. Spend that time and money to get things right. But again, it's not too expensive on the advice. If you are well prepared and you ask questions, you will get better advice. You will get better outcome for the money that you're spending as such. But I don't have a specific answer, but I would suggest that keeping a lakh or two as you start from an India perspective is a good thing. The other question that you ask is, when is a good time for startup to approach legal consulting firms for validating? It is before you get going and spending money on your tech and everything else. Remember that if your idea is not getting into the regulatory framework, then what you are building is a waste of money, right? So the first comes a check before you start to spend. And therefore, if your idea, like I said, is unique, or you are saying that, hey, very few people are doing what you're doing, I would go and get that validated as such. And in any case, as you start to get formed in a organized way as a company or what have you, you would want to hire services of professionals to make sure that all is good and you're not wasting your time and money at a later point in time. It's best to fix it first time and all times. Someone had a question for me?
Hi Vivek, Nilay this side. So basically, we are a software company, and what I would like to understand from you, if we are trying to serve customers based in US, it's like export of software and services. I mean, technically, do we need to have a legal entity registered there, or without that also on our private limited, registration in India, can we do that particular business?
Yeah, Nilesh, so you could export without being required to register in the US. At Persistent, we incorporated our US entity way back, in 2001, but that was after 11 years of existence. And it was seamless. It continues in the same manner. You don't need to have a landing entity in the US for you to do business in the US, which means that as you are exporting, you could draw a contract between a US company and India company, and it becomes seamless. People create for various reasons, including for visa situations, for multiple different things. And at times, customer force you to say, hey, you know what? We will do work if you have a US entity. We're more. It's easy to implement, and the jurisdiction being the US. But on a mode that your client is not pushing you, there's no need to create a US entity. As such, your India entity is good enough.
Got it. Thanks, Vivek. Vivek, just one more question. From legal perspective, when you consider your team, who all actually comes into it, founders and maybe full-time employees, do they consider from legal standpoint, even the part-time employees, interns, etc., as part of the team?
Yeah. So you're saying number of people as you count?
Yeah, correct.
Right. So those who are employee are considered from a labor law situation. Contractors or consultants, those who are, and therefore it depends on how you write the contract with a consultant or a contractor. For example, you say that, hey, you know what, is just a disguised employment, then they also get counted as employees. But if it is real consultant, what is a consultant? That he's working with you as one of his several clients. Then he is a consultant. But if say for example, you hired my services and I'm doing full time for Nilesh and his company, then it's very difficult to call me outside of employment. So it's a disguised employment. So while you may call, the name is not important. We call that substance over form. The substance of engagement is more important than the form of engagement. The form could be what you define, but the substance is what the regulator will check. And therefore, who is working full-time is an employee for you versus what form and shape that you look at. And those who are working with you in the employment capacity, full-time or part-time, or in any capacity, anyone who's working full-time would get associated as an employee. There are certain nuances to it, but that's the broader principle, Nilesh, in terms of how I would look at calculating number of people I have on roll, putting me onto the labor law situation.
Got it. Maybe still very ambiguous piece. Right now, I mean, from internships and multiple, kind of
No, so
people which we employ.
internships and all will not get counted as your employment.
Okay, got it.
Yeah. So if you have those who are interns, those who are doing training and all that, those don't get counted in your numbers. Yeah, that's very, very clear. Yeah.
All right.
Okay,
Thanks.
we can have one last question and then we'll go
Yeah,
into breakout rooms.
One simple question. Between different forms in India, company forms, can you just give you a brief in terms of how much, are there any limits on foreign ownership versus equity ownership? What are your thoughts on different forms and its ownership, citizenship rules? Any comment on that?
Yeah. So today, virtually all businesses except for certain, which are like, which touch nuclear, defense, and those where there is a national security involved, almost all businesses can be owned 100% by non-Indian residents, non-Indian nationals, or foreign nationals as such. So there's, virtually most of the businesses are and can be owned 100%, except for those who are regulated, and that is very, very limited, and where there is a national interest involved and national security involved. That's the principle. The other way of looking at is that you need one resident director, Mandar, for you to operate in India. That's another rule that has got created, so that if and there have been multiple reasons for that who do you catch, and therefore in India there has to be one resident director, and
Yes.
it need not be a foreign citizen, but who's resident today in India can be the director. Please understand that nuance, that I am a US citizen, but I have come to India for work and therefore I'm resident of India. Then I'm still eligible to be the director in India as such. Okay, so it is not the citizenship, it is the resident status of the person that determines that. So those are the two nuances, Mandar.
Very good, thanks.
Yeah. Let me see if there's one chat. All right, okay, I think
just a little follow-up on Mandar's question. You mentioned that there should be a resident director. Whether the director should be a shareholder or he can be a non-shareholder?
No, he need not be a shareholder. It could be the shareholding is not related to the resident status. The directorship, one of the director, and see, here is how we recommend. Many times the requirement is that you need to have minimum 2 directors. We generally say that create 3 directors, 2 who are in the US or wherever, and 1 you ought to have someone who is resident in India, though the control then can continue to be where you are as a company. So the practical way of looking at is that while the law says 2, create 3, and then 2 is in your local jurisdiction where your holdco is. And in India, as you create a sub or a standalone entity, there's a resident director. That is what is the law, but then you continue to control it in the manner that you want it. So that's the practical way of how you should look at it. In any case, odd number is better than even number when it comes to directorship for various reasons. But when you're doing an overseas entity, the best is to create 3 directorship positions, 2 in the host country and 1 resident in India.
Got it. Thank you.
Okay, great. Thank you for your presentation, Vivek, and a very good question and answer session as well. So the next piece, we go into breakout rooms, and there will be a number of breakout rooms. If you have additional time, you are welcome to stay for that session as well. You can go into a breakout room where if people have more questions, they'll ask you on that particular topic. But if you need to leave, that's fine too.
Yeah,
So
I can spend 10 more minutes answering questions and leave by 9:15 India time.
So
And
what you can also do is once we do breakout rooms, you can hop from one breakout room to another, and whichever room you are in, I would request the people to have sort of prioritize if they have any questions to you. If not, you can hop on to the next room. That way you get more
Sure.
one-on-one time with the people.
All right, thank you. Great talking to all of you. And it's easy to reach me. My name.surname@legallogic.com for any questions that you have. Thank you so much.
Thank you, Vivek. I appreciate
Thank
your
you, Vivek. Thank you.
presentation. Okay, Dev or Biraj, can you please make breakout rooms?
Yeah, the breakout rooms are open.
Okay, and then Dev, you can put Vivek into one of these rooms. If he needs to hop in, he'll come to the main one. So just explain that to him, and then you can put him in another one.
Yep.
Thank you.
Mayur will meet at breakout room number 1.